Good afternoon, everyone, and welcome to our webinar. We're happy to welcome back Mrs. Nancy Bélanger, Commissioner of the Lobbying of Canada, as well as Monsieur Mario Dion, Conflict of Interest and Ethics Commissioner. My name is Lynn Saloon. I'm one of the advisors at the Office of the Conflict of Interest and Ethics Commissioner, and I'm acting here today as moderator. As was the purpose of last week's, our first webinar in French, we are providing a general overview of the statutes that both Mrs. Bélanger and Monsieur Dion administer. So Mr. Dion administers the Conflict of Interest Act as well as the Conflict of Interest Code for members of Parliament. Mrs. Bélanger administers the Lobbying Act as well as the Lobbying Code of Conduct. Can you please both provide us with some explanation as to who is subject to the rules that you both administer? Madame Bélanger?
Thank you, Lynn. Good afternoon, everyone. Thank you so much for joining us for this webinar. I'm very pleased to be doing this with my colleague, Monsieur Dion. I have the mandate to administer the Lobbying Act, and I don't do it alone. I have a great group of staff in the office who support me in that position. And what I'd like to start with is reminding people the preamble of the Lobbying Act. The first element is that it is recognized that it's in the public interest that we have access to the federal government. The second element is the recognition that lobbying is a legitimate activity. And it is important to recognize that because our decision makers need access to information and data to be able to make decisions that are in the public interest. The third element is that it recognizes that Canadians are entitled to know who lobbies the federal government. So who is subject to the Lobbying Act? It's any individual who is paid to communicate with public office holders. Public office holders, and if you look at the slide that should be coming up soon, includes really all public servants, most public servants, governor and council appointees. It includes ministers, their staff, senators, and including members of parliament. If you communicate with any of those individuals about an amendment or the development of a bill, of a legislation, of a regulation, of a program, of a policy, or if you're asking for some form of financial contribution, you need to register and you are subject to the Lobbying Act. There are two types of lobbyists. The first is a consultant lobbyist. So these are individuals that receive a mandate. They are paid to communicate on behalf of a third party. There are also in-house lobbyists. So these are individuals that work within a corporation or an organization and whose some part of their duties is in fact to lobby the federal government. If you are a consultant lobbyist, you also have to register if you undertake to arrange a meeting with a public office holder or if you are attempting to obtain a contract with the public service. We actually have about 9,000 active registrants, active lobbyists in our registry in the last year. So that is overview of who is subject to the Lobbying Act.
And the Act has been in force since 2007, just like my Act, or 2006?
2008.
After.
We celebrated our 10th anniversary, actually, this year.
Okay. So the Conflict of Interest Act was passed in, I think it's July 9th, 2007.
Yes.
It was part of the Accountability Act. It was part of the same bill, essentially, that gave rise to the Lobbying Act. And the Conflict of Interest Act essentially sets out the rules governing the conduct of public office holders. There are two categories of public office holders, and I'll go back to this a little bit later. But it sets out the do's and don'ts, essentially, in the area of conflicts of interest for about 2,700 people are governed by the Act itself. 2,400, sorry. So first statute we have is the Conflict of Interest Act, governs ministerial advisors, so people who work in a minister's office, without exception, are public office holders. The exempt staff, the political staff in the minister's office, we have 566 as of the end of the last fiscal year people. It goes from the driver to the chief of staff in each of the minister's offices. It also governs the conduct of governor and council appointees, including people who are appointed by a minister and whose appointment is ratified by the governor and council. It covers ministers of the crown, those the people we talk the most about when we think about the Conflict of Interest Act. 30 ministers of the crown as of the end of the last fiscal year, and 35 parliamentary secretaries are governed by the act as well. And it also governs part-time, whether you're part-time or full-time governor and council appointees. The obligations are different, but you're governed by the act, whether it's part-time or full-time. It's about 1,800 people who are GICs, are governed by it, in addition to 566 ministerial advisors and ministers of states and state and parliamentary secretaries. So that's the act. The act also governs such illustrious people as the chief electoral officer, the parliamentary budget officer, and there's a short list of positions that are listed in the definition under Section 2 of the Act, I believe. The code is the second instrument, which is administered by my office, the code governing the conduct of members of parliament in conflict of interest matters, which was passed in 2004 and amended on several occasions since then. And it only applies to members of parliament, all of them, 338 people, unless there are currently vacancies, but everybody who is a member of parliament is governed by the code while they are a member of parliament. From the moment their election is declared to be completed by the chief electoral officer in the Canada Gazette to the moment they resign, they die, or they lose. Until such time as Parliament is dissolved. Sorry, the House of Commons, Parliament is dissolved. At that moment, the code ceases to apply to them. So essentially, those are the two instruments. There are people, you may have guessed that some people are governed by both, of course. The Prime Minister, ministers, and parliamentary secretaries are governed by the two documents in parallel at the same time. They must abide by the obligations set out in each of the two instruments.
Thank you. Under both the Lobbying Act and the Conflict of Interest Act, the term public office holder, is defined. However, we do find a designated public office holder under the Lobbying Act and a reporting public office holder under the Conflict of Interest Act. Can you both give an explanation as to the differentiation between those two terms? Mr.
Maybe I'll
Dion?
start. It's fresher to the memory. We just talked about it, the Conflict of Interest Act. So, who is a reporting public office holder?
Yes.
Minister of the Crown. People who work for a minister and who work more than 15 hours a week, or 15 hours or more, sorry. So 15 hours or more. These people are reporting public office holders. Then you have, of course, parliamentary secretaries, as well as the staff who are working 15 hours or more. You have GIC appointees, or GIC-approved ministerial appointees who are on a full-time basis or receive an annual salary and benefits. So they are reporting public office holders. The chief electoral officer, the PBO, the parliamentary budget officer, and other designated persons. There are a few other designated persons. And these people are essentially belong to the class of people, the upper crust, I would refer to them. So everybody is a public office holder, but the reporting public office holders have additional obligations. Mm-hmm. Among the most difficult, if you wish, obligations, the most exigent, if that's a word in English, obligations, in that they must publicly disclose their assets and liabilities. Only the reporting public office holders have to do that. And they also have to publish a declaration of such assets and liabilities. They also are facing prohibitions concerning outside activities. So there's a section in the Act which prohibits essentially the exercise of a profession, employment, business, and a number of things. That's Section 15 of the Act. This only applies to reporting public office holders. And finally, they shall not hold controlled assets, which are referred to as controlled assets in the Act. So shares of companies, for instance, publicly traded companies, for instance, you cannot hold those. You cannot keep those. You have to either sell them or you have to place them into a blind trust, administered or approved by our office. Mm-hmm. So that's the type of obligations that they're facing. And they represent 45%. So it's the upper crust is also a large group. It's 45% of the people governed by the Act are reporting public office holders. So I hope this answers your question.
Absolutely. Madame Bélanger?
So as I've just stated a little earlier, lobbyists have an obligation to register on the registry when they communicate with the public office holder. So those are all public servants, ministers, their staff, government council appointees, members of parliament, and senators. They have an additional obligation to report monthly in the registry every communication that is arranged in advance and oral with a designated public office holder. So who is this group that creates this additional obligation on lobbyists? Those are listed here on the slide that you have in front of you. It's the ministers and their staff, GIC appointments. It's deputy ministers, assistant deputy ministers, associate deputy ministers, then members of parliament and senators. So if a lobbyist has a discussion that's been arranged in advance with any of these individuals, they have an obligation the month following the time they've had the discussion to report that in the registry.
The public registry.
In the public registry. One of the things we do at our office is that every month we verify 5% of the sample of all of these monthly communications report is what we call them. And we verify with the designated public office holder who was named as the person who was lobbied. We verify with them the accuracy of the information that was entered on the registry by the lobbyists. And we have found that more than 94% of the information is accurate, which is very good for transparency. And the errors are most of the time extremely minor, where it's misspelling a name or it's something like the title was not appropriately identified. But individuals who do enter the information are entering it accurately. Very important is that the definition is the group of people that are subject to their 5-year prohibition when they leave office. So anyone who fits into this category of people when they leave their position as a designated public office holder, they are subject to the 5-year prohibition from lobbying under the Lobbying Act. They may have some responsibilities, post-employment obligations under the Conflict of Interest Act, but they certainly do under the Lobbying Act, not entitled to lobby. There are some exemptions. They can apply to be exempted, but those are very limited in circumstances, and they should really know about the prohibition.
Okay, well, thank you. So public office holders, lobbyists, members of parliament, they all have to observe the rules that you administer in order to maintain that public confidence, that public trust. What do you have at your disposal to help foster that trust? We'll start with Monsieur Dion.
So last week in the French webinar, I think the first guarantee is that the office, and I'm not alone either, just like Madame Bélanger, I'm assisted by a team of very competent people, but I am independent by law, objective by practice. And this is, so in other words, it's non-partisan. I have no no feeling that I have to make life easy or difficult or so on and so forth. I'm here to implement the Act as Parliament had planned that it should be implemented back in 2007. So that should be one element of public trust, the fact that the Act is administered by somebody who's appointed during good conduct, who doesn't fear losing his job whenever he has to make a decision. In fact, he doesn't fear losing his job. Second guarantee that should give the public some reason to believe that this is a serious regime is the public registry. We also have a public registry, in which we declare a slew of different information as provided for in the Act. It's a searchable database, so anybody can go 24/7 on the public registry, which is located on our website, and basically look up an MP, look up a person governed by the Conflict of Interest Act and determine, when their declaration was made, whether they have a filter preventing them from interacting with certain issues and certain people, so on and so forth. So it's in real time, essentially. It's updated daily, regular. Every time we touch something, we update the registry when it applies to the registry. Another guarantee is the fact that every investigation report, because one of our roles, we provide advice to MPs and people governed by the Conflict of Interest Act, but we also investigate when information comes to our knowledge, whether through a complaint or otherwise. We do investigate when somebody alleges, or there's an allegation, if you wish, that a breach has occurred under the Act or the Code. So every report, investigation report, is made public. At the very same time, it's made available to the person whose conduct was the subject of the allegation and the person who complained if there was a complaint. The very same day, a few minutes after, it's in the public domain. So somebody who has an interest in the media or in the public can actually follow in real time what's happening in an investigation after it has been completed. We're bound under law not to reveal anything until such time as the investigation has been completed. And the last one is the fact that I do have some limited, but yet some power to impose monetary penalties. When a reporting public office holder fails to observe his or her obligations under the Act, it's possible for me to impose a penalty of up to $500 for a failure to do something when they were supposed to do it, or at the appropriate time, or in a complete fashion. And so we're doing that several times a year as well, 15, 20 times a year. I don't have a quota or an objective, but whenever we see a situation where there was a failure to comply, we analyze the situation and we decide whether to resort to an administrative penalty. So those are the four things that come to mind.
And I can tell you that I'm informing your office of my every moves to ensure that you don't impose one on me. On my side, the tools that we have, obviously we also have the registry, and that is an absolutely important tool for transparency. It is important for Canadians to know who lobbies which public office holder about what subject. The next tool that I have in the Lobbying Act is a mandate for education and outreach, which is one of the purposes of our joint webinar today. I think it is important to inform as many people as we can, whether you are subject to the Lobbying Act or not. It's important for Canadians to know how the system works and how we are trying to keep people that work in the public service or actually have rapports with the public service, have ethical standards, and there is transparency. So for me, it is important to have outreach and education mandate. The third aspect of the Lobbying Act is to give me the mandate to ensure compliance with the Act and with the Code, which I'll talk about in a few minutes. But under the Act, if you miss a deadline, if you provide misinformation, if you don't register and you're lobbying, or if you are lobbying when you shouldn't because you're prohibited as a former designated public office holder, those are all offenses. And they are subject to quite heavy fines and as well imprisonment. So it is important to take the responsibilities of the Lobbying Act seriously. Now, if I have reason to believe while I'm investigating that an offense has occurred, I have to suspend my investigation and send some information to the RCMP, who will decide what are the next steps. If the RCMP chooses to charge someone and someone is actually convicted, I have the power to impose an additional prohibition on lobbying for a period of up to 2 years. Where the RCMP chooses not to pursue the matter, it's sent back to me, and then I can finish my investigation and report to Parliament. There is also the Code, so I can investigate breaches under the Code. And if I step back a little bit, as the Lobbying Act actually provides the power to the Commissioner to develop a code, to actually set the ethical standards, the behavior upon which we believe lobbyists should abide by when they're dealing with public office holders. If I believe that there is a breach to the code, I also investigate. And this, if there is a breach, will usually lead to also a report to Parliament. I do have the power to cease investigations for any valid reason, passage of time. There is another legislation that is dealing with the matter more adequately than what we can do. And that tool is available because, you know, reports to Parliament to me is an absolutely, it's an essential tool, but it's also something that cannot be taken lightly in light of the fact that we are dealing with people's reputation and their livelihood. And so therefore we take the natural process and procedural fairness seriously. I do have an obligation under the Act, if I am going to find someone in breach, to give them an opportunity to comment and give suggestions and give representations on the report before I actually make my findings public.
And we have the same process, of course.
Yes, yes.
Virtually the same provisions, in fact. Right?
That's right. And I'd like to add that not everything leads to an investigation, right? I have to have reason to believe that an investigation is necessary to ensure compliance. There are areas, and there are a lot of times where, while we're doing a preliminary assessment of the issue, the individual will voluntarily admit, or actually there will be the ones to call us to say, I did this and I did not know that I shouldn't have, or I'm late for 2 days, so there are mechanisms in place to try and deal with these individuals without everything leading to a report to Parliament. We usually monitor these people. We either will give them advisory, stern letters. We will monitor them for possibly up to a year. We, as well, sometimes will impose and ask them to do some webinars or training with some staff to ensure that they understand the obligations and the rules appropriately.
Okay. Mr. Dion, you mentioned the public registry and all the different various public declarations that we can find, the public can find in them. I assume that the public declaration of gifts and other advantages are of great interest. Can you provide a little bit more explanation as to the provisions that affect both members of Parliament and public office holders when it comes to gifts?
Yeah, I'll try to explain that in simple terms. It's relatively simple. So in the code, there is a section applicable to MPs, as I said, from cradle to grave, as you say in English, who basically from the moment they are elected to the moment they are defeated, and it's section 14 of the code. And I always go back to the source because the crafters, these things were crafted with great care, I think. I wasn't there. But section 14 says, neither a member nor any member of a member's family. So a family is it's defined earlier in the code, and it's the immediate family. The spouse, whether common law or legally married, and the dependent children, period. That's what the family is for the purpose of the code. So a member cannot accept, nor a family member of a member, any gift or other benefit that might reasonably be seen to have been given to influence the member in the exercise of his or her duties, basically, essentially. Reasonably be seen to have been given. So that's a no-no. The gift is not acceptable. In the Conflict of Interest Act, the other group I was talking about, and again, ministers are governed by both, as well as secretaries of state, there's a section called Section 11. It's not called, it's numbered Section 11. And it's essentially the same words. No public office holder or member of his or her family shall accept any gift or other advantage that might reasonably be seen to have been given to influence the public office holder. So it's pretty simple. Reasonably be seen. It's not how you feel about it as an MP or as a person governed by the Conflict of Interest Act. It's how a person located outside of the situation, looking at it, what they would think, what she would conclude if she knew that you were offered X, Y, Z by this person at this moment. So are there reasons to believe that this gift has been given to influence you? Is it reasonable to think that it's been given to influence you? If so, it's a gift that's not acceptable. There are exceptions. So a gift is not acceptable except in 3 situations under the Act. the Canada Elections Act, so political contribution. A gift that's given by a relative or a friend of yours or of your family member is also appropriate. Or a gift that's received as a normal expression of courtesy or protocol, and we'll talk about that later with examples. Or that are within the customary standards that normally accompany the public office holder's position. So we'll talk about that. So the public registry contains declarations. People have 60 days under the Act and 30 days under the Code, or vice versa. Sorry, 60 days under the Code, 30 days under the Act, to declare a gift when the value of the gift or the advantage exceeds 200 Canadian dollars at this time. So you basically, if a gift is acceptable, you accept it, and you have X days, 30 in the Act, 60 in the Code, to declare it if you believe it's valued at it's worth more than $200. A gift can take several forms, of course. The ultimate gift is money. I like to think that this is not very common, but somebody gives you money, whether cash, whether it's a loan that you don't have to repay. That's obviously a gift. A service. A few weeks ago, we had the situation of interns who were made available to members of Parliament free of charge. They were not volunteers; they were being paid by somebody else. So that's an advantage as well. It's a gift. And another thing mentioned in the Code and the Act is the property or the use of property that's provided without charge. So I'll let you have my condo for the next 3 days in Mont-Tremblant. That's obviously also a gift or an advantage. Anything that you get at free of charge or at less than its commercial value. Pretty simple to understand. You have to declare it if it exceeds $200. So we spoke about the friends, we spoke about 200, and of course, if the same person, and it has never happened to me in my life, if the same person insists on giving you gifts after gift, you have to declare publicly as well the moment that the sum total of the gifts that the same person has given you over the last 12 months exceeds $200. I like to think this is not too frequent either, but it's written in the Act that you have to, and the Code as well.
It's under the Code.
That's it. 200 cumulative. Okay. Okay.
Yeah.
Not in the Act. Okay. So grosso modo, that's it, and we'll use examples later to illustrate. So what does that mean to a lobbyist?
Yes, thank you.
What does that mean to a lobbyist? Well, contrary to your regime, the Lobbying Act is actually silent on the issue of gift. And it's under the code that's been created by the commissioner, where the gift is actually articulated and the rule is set out. Gifts is definitely one of the issues that's most questioned. I'm sure it's the same in your office. Every day we have one that comes in, and it is difficult to understand. And most of the time, I think it's because it's such a case-by-case analysis that needs to be done. Under the code for lobbyists, the rule sets out that to avoid a sense of obligation on the part of the public office holder who receives the gift, lobbyists should simply avoid giving a gift to someone that they're lobbying or that they plan on lobbying. There's the exception where it is understood that the public office holder can accept it. And so to be able to interpret this, the guidance document has used a lot of the same explanations that you've just given, the exception around protocol and courtesy. Sometimes the tickets and the receptions and the galas are the things that actually we get often asked about. And you've got to be careful. And quite frankly, you should be calling our office if you're not certain whether or not the gifts should be given. The general rule is try to not target a group of public office holders. If you do a reception and you don't target, you invite everybody, keep the amount to a very reasonable value of the reception. Try to avoid lobbying during that event, but if it occurs because it's an inadvertent or something happens, you need to put it in the monthly communication report if it's a designated public office holder. And I do encourage you, again, to call us, because I think it's one of these issues that you don't want to have to deal with again at the end of it if we have to do a report on whether or not the gift should have been given. Be
So
careful
that's-
and vigilant.
So what Nancy has just said applies, of course, to the person who intends to offer a gift or an advantage, and the person who has to determine whether he or she accepts.
Has to call
So
you.
the concept of acceptance is essentially you say, okay, that's fine, I'll take the tickets, even though it's something that might happen 6 months from now. You accept from the moment you accept, and if it is acceptable under the rules that I've explained, then you have 60 days or 30 days to declare it from the moment you accepted it. Okay? That's one small nuance. But whenever a lobbyist is involved and a lobbyist is registered to lobby a group to whom you belong, it's very touchy. And I too
agree.
would recommend that before you decline, it's fine. You can decline without talking to us. But before you accept, I think you would be well advised to consult with your advisor at the office, because the advisor has a number of advantages over you involving the situation. Point one, the advisor is objective. The advisor doesn't want to go to the concert, or the advisor doesn't want, it's not him or her that will have to decline. Number two, they know the precedents much better than anybody else, because they've worked in the area for a long period of time usually. And number three, if you're an MP and you seek advice, and if you're a person governed by the Act, you seek advice in writing, and we reply in writing, we're essentially bound by what we tell you. So if we say it's fine, you can accept the gift, you accept it, then there can be a complaint. You basically have a guarantee that if you disclose all the facts, of course, you have a guarantee that you'll be protected against an investigation or a complaint.
Terrific.
Yep.
Okay, so we're going to move on to some questions. I don't think I mentioned it earlier, but please use the chat window at the bottom of your screen to submit any comments or questions you may have. Commissioners will be happy to answer those questions. So let me start with, what can constituency office staff accept from constituents as appreciation for a job well done when their immigration case is concluded?
It's a new question.
That is a new question.
Do you have a new answer? Okay. So they are constituency staff are not governed by either the code nor the Act.
No, they're
Well, that's the
representing
answer.
their member.
And they're still bound to behave ethically, but it's not essentially something I'm responsible to answer. But I will nevertheless answer it. A token expression of appreciation, such as a cheap bottle of wine, not a Chateau Lafite 1952, but regularly priced, reasonable bottle of wine might be fine. But it's not for me to say, because they're not governed by either the code nor the Act. The MP is governed by the code. Mm-hmm. And if the MP was to be offered the same thing, then the general rule, which I've explained, cannot reasonably be seen as having been offered to influence the MP in the conduct of his business as an MP. If so, he should refuse the gift, or she should refuse the gift.
If a lobbyist is also a close friend of a member, can that person invite the member and their family to spend a week at their chalet over the holidays?
A member of parliament, you mean, right? Okay.
A
By
member of
definition,
parliament,
okay.
that's correct. So
Can the lobbyist invite the member?
Can the invitation be extended, and can the invitation be accepted?
Well, it's a good question. So
Depends on the cottage. Don't you?
Absolutely. It depends not just on the cottage, but I think on the relationship of the two individuals at issue. Under the code for lobbyists, what I would be looking at is whether or not it does create a sense of obligation. And if this lobbyist is registered to lobby this particular individual, not only does it possibly create a sense of obligation on the part of the member of parliament who's a friend, it also raises the issue of another rule in our code about preferential access, of being able to lobby someone with whom you have a close relationship, which you should avoid doing. The interesting twist in this is the fact that if my colleague here were to say that because they are friends, it's acceptable,
I won't say that.
You won't say that, but if you were
Because
to
the
say
code does not have an exception for a
for
friend.
friend, well, there you
An,
go.
an MP does not, the MP may have friends, but the friends are in the same situation as they were not friends. They're not
All right.
listed as an exception.
So therefore, if you were not to say that it is acceptable for the MP to receive, I would be inclined to say if the relationship is one of someone with whom that you will lobby, is to avoid giving the gift even though they're a friend, because there may be other implications as well.
So I think I've answered the question. We're talking about an MP in the question.
Yes.
And an MP, the test is, would a reasonable person outside of the situation think or see this as having been given to influence you? If so, you should abstain. If you don't abstain, if you accept the invitation and somebody complains, or we learn about it in Le Journal de Montréal or elsewhere, we may have to take some action and investigate the situation.
Okay.
A person is not divisible. It's the same person. Friend plus lobbyist, same person. It's hard to distinguish. The facts would weigh heavily in the balance. The duration of the relationship, the habits. If you've been to that cottage for the last 27 years and you were elected 3 weeks ago, it may have an impact. We would have to look at the totality of the facts, but prima facie, it could be a problem.
Okay. If a group would like to offer USB keys with an information package reflecting their company mandate, we'll say, to all members, would this constitute a gift, the USB key?
So, a USB key nowadays, I think last time I looked, is not a very expensive piece of equipment. It's usually. So we're not talking about the medium, the support, if you wish, on which the information is located does not appear to be an expensive gift. So I don't think anybody will think that you'll be swayed because somebody gave you a key that you can buy at Best Buy for $14.95 or $9.95 or maybe $2.95. I didn't look recently. Cheaper and cheaper. The information itself, of course, depends on the value of the information as well. Does it have a market value? If on the USB you find electronic books that you would have to pay large sums of money in order to acquire, then it makes a difference. Again, would a reasonable person think that this USB key and the content of the USB key, and Nancy will have a comment on that too, the content also, the information by its, so I'm talking value. Let's look at what is on the USB key, if it's valuable or it's not worth 5 cents. Sometimes it's not worth anything on the market. That would determine the issue. But then, why would you give me a USB key with information on it? The nature of the information could, I think, it's not my realm, but it could constitute lobbying.
Absolutely. I think that's what's important. The gift of a USB, maybe someone would argue that it's a means of communication rather than being paper. They're
like
giving
paper,
the information on the key. I think for us, what would be important to see is the information on the USB key is actually a communication for the purpose of lobbying. We've got to make sure that the lobbyist, the person offering, is registered if it is meant to go towards public office holders. So it will depend on what message is on that USB key. When is it given? Is it given during a lobby day versus a gala versus a reception? So I think we need to look at the circumstances of the facts around the USB key. So nothing's ever simple. It's always complicated.
If you pick it up at a kiosk, for instance, at an exhibition,
Yes.
it's one thing. The lobbyist doesn't offer it to you. You basically pick it up like any member of the public could pick it up. Then it's another factor.
Yeah, that's right. It will depend on the circumstances are surrounding this donation of the USB.
Okay, so we received another question. Are Director Generals and or Assistant Deputy Ministers covered by both or either acts?
They're not governed by by our act, for sure. DGs and ADMs are not governed by the Conflict of Interest Act. Unless they get elected, then they will be covered by the code, of course.
Under the Lobbying Act, what's important is that they are covered, but for the purposes of the responsibilities of the lobbyist. So if the lobbyist intends to communicate with any public servant, so it includes the DGs and it includes the directors, it includes anyone, any public servant, really, most of them, there's a few exceptions, but I think the lobbyist will be required to register. The designated public office holders, so those individuals that are subject to the 5-year prohibition, assistant deputy ministers and associate deputy ministers are subject to the 5-year prohibition, but not the DGs.
Okay.
And the associate deputy ministers, because your question was about ADMs, assistant deputy ministers and DGs, not governed by the Conflict of Interest Act, but associate deputy ministers are governed.
That's right.
Because they are appointed by order in council.
That's correct. Okay, so I have a question for Ms. Bélanger. For violations of the Lobbying Act, can you please elaborate further on typical fines and/or imprisonment terms? Also, are there examples you can share of cases that have been referred to the RCMP? What was the outcome of those cases?
So if I believe that there is a possibility of an offense having been committed, I suspend automatically my investigation and I refer it to the RCMP. There has been, I believe, 4 cases of convictions where the former commissioner referred the matters to the RCMP that led to charges and convictions. If you go on our website, there will be some, in 4 cases, a prohibition was imposed on these individuals following their conviction. And so their 4 cases will be there. Certainly the most famous one that has been in the media was Mr. Carson. He is one of the example. In all cases that's been fines, and I do not recall what was the most, I think it might be 25,000, but I am not sure.
50,000.
50,000? 50,000.
The producer tells
The
us.
producer just told us it was 50,000. But there's been appeals, so I'm not sure that this is a final file yet. There has been appeals of the parts of the conviction, and there has been no imprisonment.
Okay. I think we have time for one more question. Okay, so if an individual that is not registered to lobby, but is part of an entity that represents the interest of a particular group that is seeking something from the public office holder or a member of parliament, can that individual give a gift to either the public office holder or member of parliament, and can the member of parliament, public office holder, accept that gift from this individual?
I skipped a few words when I read sections, remember sections 14 in the code and 11 in the act. It says you shall not accept directly or indirectly. I skipped those words, but I think they're applicable to the answer to this question.
Well, I would say, first of all, is if the individual should be registered, will have to be looked at. And if they should have been registered, certainly the code would apply to them. I don't think you can use an excuse, I was not registered, therefore I can give any gift that I can. The code will apply to anyone who should have been registered and they are lobbying without being registered.
And you have a 20% rule, I think, if I'm not mistaken,
Well,
which you don't like, but it's still there.
I don't like it, but the 20% rule applies, but I don't know that it would apply to the scenarios because this is someone who's been hired to represent the interest. If someone works within a corporation or an organization, the obligation to register only arises once they've met their 20% of their duties. So 20% of their function is to lobby, then they have to register.
Right.
And if they should have registered and they didn't, and they provide a gift, then I think this would cause some serious concern. I'm not sure that it would be acceptable under the code nor under the Lobbying Act and the Code of Conduct for Lobbyists.
Okay, well, thank you very much. I want to, again, thank you for your explanations, providing some great explanations as to help better understand the statutes that you both administer. I also want to thank all the participants today. Thank you. I'm sorry we didn't get to all your questions, but we will be providing some answers on Twitter in the near future. So please follow both offices on the Twitter account. And I hope you have a nice evening. Thank you.
Thank you
Thank you.
for joining.